Hi, welcome to our Know Your Rights live stream tonight. I'm Mickey Rice and I'm from MAP. And I've got Megan Sway, the policy director with ACLU here, and I've got Hillary Knight, who is a former public defender and a current practicing Maine attorney. And I'll give you both a second to introduce yourselves if you'd like.
Sure. Hi everyone. My name is Megan, as Mickey said. I am the policy director at the ACLU of Maine, and I work sometimes with MAP on policy in the legislature. I'm so excited to be here.
We're excited to have you as well.
Hi, I'm Hillary Knight. I use she, her pronouns. I am currently a Maine lawyer, and prior to that, I was a public defender in Worcester, Mass., which is how I got involved with harm reduction. I'm just a huge fan of MAP. I like to think of myself as like the lawyer friend that people can ask questions to. So I'm excited to be here and great to be with you, Megan. Thanks.
Thanks. Yeah, it's great to be with you both as well, and thank you for doing this live stream with us. So yeah, we pretty much just wanted to do this live stream tonight because there's big changes coming to Maine's Good Samaritan law coming this month, and with that, we also thought that it'd be a good time to kind of roll some other Know Your Rights stuff in there with it. So some people might not, most of the people that follow Maine Access Points, I would think, would know why we needed to expand the law for the Good Samaritan law in Maine. But I thought that a good way to kind of show and explain why we needed the changes that we needed with the Good Samaritan law by playing one of the testimonies from the public hearing in the legislature. So I'm just going to share my screen real quick, and it's actually our very own executive director, Hillary Esslinger. I think she did an awesome job at explaining why we needed to expand the law, because we did already have a law in place, but as you know, you'll learn if you don't already know during this live stream, it definitely was not doing what you. So I'll just start playing this. It's only about 3 minutes long.
I'm not hearing it.
Hold on just a second. I think I didn't click that button for the audio. Yeah.
Good morning. Hi, good morning. Senator DeChambeau, Representative and honorable members of the committee. My name is Hillary Esslinger, and I'm speaking on behalf of Maine Access Points in my role as executive director. It is a privilege to be speaking in favor of LD 1862. MAP provides access to overdose education and naloxone distribution to everyone with 3,206 participants across the state. Outside of individual programs, we serve multiple community organizations, recovery centers, businesses, treatment providers within our role in the Maine Naloxone Distribution Initiative. We work really closely with participants to debrief instances of overdose, both as individuals experiencing the overdose and as someone responding. Through these relationships, we collect information from overdose reversal reports, and we understand that most of the individuals who report back to MAP do not call 911 in fearing negative consequences. With that being said, and I think this is very important to note, people also risk their freedom all the time to call 911, and they should not be in the situation to have to make that decision while saving somebody's life. We have a lot of data that we can share at your request, but I really wanted to speak to the individuals who will be most impacted by LD 1862. People who use drugs and their loved ones are on the front lines of the overdose crisis, creating networks of care and saving each other's lives. Never use alone is a message we share a lot with these networks. These important messages are held close by our community, and with this in mind, people come together to share in company, safety, collective responsibility to each other as they use their drugs. I am not sure who we imagine to be at the scene of an overdose who does not deserve the safety of LD 1862. I picture the individual who is identified as a community caregiver and opens their homes to their friends. The local naloxone distributor stopping by the house at the request of their community. Our society perpetuates the criminalization of people who use drugs, and we know the reality of people's personhood is much more complex. We speak to people who respond to 30 plus overdoses in a month, showing up for their community time and time again. I experience critical hope when I think of the deep history of saving each other's lives every day across Maine. There is a powerful connection within our networks because systems have forever let us down. Share deep grief for those who have died from overdose because they were alone and didn't want to put someone else at risk. So Maine needs a safe supply, and we need to create public policy that addresses that. But in the meantime, we really need to protect our neighbors from experiencing criminalization at the scene of an overdose. So many citizens in Maine, people we all know, save lives by being at the scene of an overdose. And if they were responding to a different medical emergency, they would be deemed heroes. We are well aware that 636 individuals died of drug overdose in 2021, and I cannot fathom how many others would have died if this care didn't exist in our community. I see I have time. I want to share my immense gratitude for the folks in Maine who just show up every day to save each other's lives. And I urge you to stand in solidarity with us and vote on to pass. 200.
I hope everybody was. But yeah, one thing that I just want to add to that is that while going through the different testimonies, there was a lot of wonderful testimony that day. I picked Hillary's just because I think it most broadly covered some of the reasons why and some of the things that, you know, we see working with people who are saving people, you know, other people's lives every day. But there was definitely some very powerful testimony that day with, you know, personal stories. And so, but ultimately we did change the narrative enough that showed the narrative enough that we need to save lives, and we're able to get it passed. So it goes into effect on August 8th. And Megan actually has a PowerPoint and some information to share with us about the law that goes into effect on the 8th. Sorry.
Sure. So I'm just going to quickly go over some points about the law in case folks don't know the finer details. Of course, I said that, and this is going to be a broad overview. There are a lot of like nitty-gritty details, and if you want the nitty-gritty, you should reach out and we'll try to get them for you, or you should reach out to your lawyer. But this is just to give you a sense of what this law says, and then we'll move into Hillary talking about the practical implications. So what is a Good Samaritan law? In general, it is based on the concept of the Good Samaritan in the Bible, someone who does a good deed. For states across the country, we've passed Good Samaritan laws to incentivize people to call 911 in the case of, in this case, in the case of a drug overdose, but also there are other medical emergency Good Samaritan laws. But in our case, we're talking about incentivizing people, making it safer for people to call 911 when they suspect someone's having a drug overdose. And what it does is that it provides some sort of legal immunity for people at the scene, so that they can feel comfortable calling 911 and not worry about being picked up on mostly drug charges, but we'll go into the specifics. So we are, as Mickey mentioned, we already have a law on the books. It was passed in 2019. And this law is in effect until August 8th when the new law takes over. This law was really limited and it only protected people who basically called 911 or were experiencing an overdose. And it protected them from arrest or a probation violation for drug possession, acquiring drugs by deception, or using drug paraphernalia. Those are all three really minor crimes. And if you had if you had enough drugs on you, if you have enough drugs on you, it's still not August 8th, if you have enough drugs on you that can be considered trafficking, you wouldn't be protected from arrest or prosecution. And so, as Hillary's testimony so beautifully pointed out, that was making people have this terrible choice of, do I call 911 and risk my freedom, or do I risk my loved one's life? So the new improved law expands all these things: who's protected, the types of protection that you have, and the types of charges that are given immunity. And I'm going to go into a little bit of detail here. So in terms of who is protected, you have to be at the scene of the overdose, and you either are experiencing an overdose, you call for help, or you're quote unquote rendering aid. What does rendering aid mean? We tried to keep it really broad, and it means any action that involves looking after a person who's experiencing a suspected drug-related overdose while the person performing the action is awaiting the arrival of a medical professional. So say you're not the person who calls 911, but you are administering naloxone, you're giving CPR, you are doing any other thing that is rendering aid. We tried to not make it descriptive so that there's there's leeway in what we decide, what we consider rendering aid. But examples that are listed in the law are giving first aid or giving naloxone. So again, you have to be at the scene. You have to either be experiencing the overdose yourself or be rendering aid. And that is, a much bigger protected, like the people who are protected are much bigger now, because before it was just the person who was overdosing or the person who called for help. This immunity does end once the police or EMTs leave the scene. So it's not, it's only for the duration of calling 911 and getting medical. So that's important to know. And if someone calls you and you're not at the scene of the overdose and you call 911 and somehow they have your number, like, you're not protected if you're not at the scene rendering aid. What are you protected from? You're protected from arrest, prosecution, and revocation of bail, probation, supervised release, administrative release. All of those things, you are immune from that happening to you if what you are being arrested for or prosecuted for is not an exempted crime, and I'll get into that. But the big thing to know is that if there's a warrant out for your arrest for, say, a drug crime, you would be protected under this law from being rearrested.
Now, the bail, the bail violation, our understanding regarding any type of violation of release right now is that the original crime has to be a nonviolent crime, correct?
Yeah, the original crime would have to be a non-excluded crime. So excluded is the word we use. The excluded crimes are crimes that don't get immunity. But if you were out on bail on a drug charge, you would be protected from being violated for bail.
Yeah.
I think for our purposes, the most important thing is that all drug crimes are exempt. So all drug crimes you are immune if you have drug charges, if you have drugs on you at the scene. That is the most important thing. And then there are other, and most property crimes like theft, trying to think of other ones, those are also protected. They tried to make a distinction between violent and nonviolent crimes. I don't really like to talk about violent and nonviolent because what is violent to one person or to lawmakers may be not violent to others. And what is not violent to lawmakers may be very violent to some of us. And so I try not to talk about it in terms of violent or nonviolent crimes, but when we talk about the excluded crimes that are the quote unquote violent crimes, it's sex crime, child pornography, kidnapping, robbery, arson, and murder, manslaughter. And then if you have a protective order out against you and you have violated it, that also, like, you're not immune from arrest for that. So if you are at the scene and someone who has a protective order against you is also there, you could be arrested, and that's important for folks to know. This is not this is like the language in the bill is like goes into specific crimes, like in the nitty gritty, and I tried not to do that because I think that's really confusing. So if you're worried about something, you should definitely talk to a lawyer. But this hopefully gives you a general sense of, am I protected or am I not protected?
Yes, definitely. And if anybody's got any questions, feel free to, we can see the chat right on our screen. So if you've got any questions, feel free to type them in the chat. And we'll either, try to answer them throughout or definitely at least try to get to them at the end.
So how this is supposed to work is because this law is on the books, the police are not supposed to arrest you if you are immune, but we know that we can't count on that. And so there's a provision, there's a part of the law that says, okay, if you're accidentally arrested when you shouldn't have been, you or your lawyer can file a motion immediately in court to say, I was rendering aid at the scene of the crime. And if you provide some sort of evidence in your motion for that, then the prosecution has to come back and prove that you weren't rendering aid. So there's this, like, ideally, the police wouldn't arrest you. And ideally, the prosecutor would not prosecute you. But if those things happen, then you can still file a motion. So we're trying to put in lots of ways that we can still protect people throughout the process in case you accidentally or on purpose, whatever happens, in case you are wrongly arrested or prosecuted, that you can assert your rights under the New Good Sam law.
Awesome. Thank you. One quick question that I had, do you know if it would be like, I mean, this might be getting too much into stuff, but if you didn't have a lawyer and had to file the motion like yourself, is it something that's generally easy to do?
Ooh, that's a good question. I mean, I don't want to give legal advice about how you would go about doing it, but I think you could send a letter to the judge saying, I was rendering aid. I should, please schedule a hearing. I should not be prosecuted.
That makes sense. Thank you. Awesome. So I'm not seeing that we have. Okay.
I can offer like a quick potential something that might relate to that. So this is my experience with sometimes when you have criminal charges against you, and part of the government's evidence includes, for example, something that was found during a search, that the search was allowed by a warrant. So let's say there was a search warrant, search was conducted, down the road, there's a charge that results in that. And the defendant and their lawyer want to contest that evidence, right? And I don't know if this is actually how it'll play out with this particular law, but I can imagine it being something like, and this is a similar, we would call it like burden shifting, right? The defense says, hey, you didn't do this properly. Now the burden is shifted, right? And the other side needs to say, we did, or you actually weren't rendering aid. And so in the example with a search warrant, you might file a motion that says, based on X, Y, and Z facts, this search warrant should never have been granted. And the whole idea is that there should be some protections in place so that you're not offering up evidence that might get used against you, but you are trying to provide enough evidence that you get over this burden and the judge says, yeah, I do need the government to explain to me why they believe you weren't rendering aid, or why that search warrant was valid, or that those statements were taken voluntarily, whatever it might be. The government's going to have to show the court we did everything according to the law, and all of those safeguards were ensured.
Awesome. Yeah, that's definitely very helpful.
And it's one of those things that feels, and I can talk about this more, but I think it's certainly one of those things where in practical terms, you're going to have to wait to do that, right? You're going to have to wait until later in the process. And it's never during the arrest when you can actually assert those rights and really get into the sort of legal procedure of how and why your case should be dismissed, or why this evidence should be used.
So I was actually just I kind of lost it. I was just thinking about like what would be, because we know it's going to happen, that at some point somebody is going to be rendering aid and they're going to get arrested anyway. What would be your advice to somebody in that situation? Like I know we had talked about it a little bit when we had met one-to-one, just like being in that situation, because like obviously some people are going to think you don't want to be like yelling I was rendering aid and saying something that could be seen as going against you, but you also want to be able to kind of defend yourself so that you possibly don't get arrested or don't get charged down the line if I don't know if that made sense.
You want me to share my thoughts about that? Sure. So it's a really good question, and I think it's a really complicated question. I think first off, I can't offer like, here is what any one person should do in any one particular situation, because the facts of every situation are going to be different, but every person's also going to respond differently and have different needs and priorities. And so there's no one blanket rule. And I think there are some best practices. I'm a really firm believer in harm reduction, and I think that extends to police interactions. I think that recognizing that harm, just as a reality in our world, can come from police interactions, part of our responsibility is to know where risks are, know how to minimize those risks, how to stay just a little bit safer in any one particular interaction. And so knowing exactly what this statute says, how it's been expanded, is really important. I mean, part of what keeps you safe is staying educated. But it also means that if you know this law inside and out, it doesn't change the power dynamic between you and a law enforcement officer on the scene. And so you might be right all day long, but you cannot physically outpower that person. And so you just have to hold on to that argument for later. And that can be really hard. I don't want to pretend like that would be an easy thing to do. And certainly, we all respond to stress differently. We all respond to anxiety and just chaos, crisis in different ways. And so it's really hard to know exactly how or what you would need to explain or what kind of information you're trying to get across. I have some slides that might help to sort of think about what's important to communicate in an emergency. When you're trying to decide, do I need to remain silent, literally silent, remain silent, or how can I render aid by communicating information? But it's, I think, just knowing what your rights are no matter what, and also like know it inside, but know when and where you're going to have to make that argument and when to stop. Know when to fold them.
Yeah, something else that I think you alluded to as well is just kind of like being forgiving with yourself too. Like if, you know, like, I mean, cops can say and do numerous things to get somebody to either feel like they're on their side or feel scared or feel, you know, any type of way. And just like also coming out of that and or even during it, realizing like, you know, maybe what I'm saying isn't going to be able to stop the situation, but like, you know, kind of trying to be able to have that in the back of your head of like, I will have a later point in time to be able to try to, you know, right this situation, and just realizing that, you know, just be gentle with
yourself. I think in an ideal scenario, you can sort of make mental notes of facts that you want to remember later that will help demonstrate, you know, 911 calls are recorded. And so if you're communicating to a dispatcher what you need medical assistance, we have a medical emergency, I need an ambulance. That's evidence, right? That's something that could be used down the road by either side. So those statements will be recorded and be a part of this. If there's a criminal investigation or an arrest, that will certainly be part of that record. And so knowing when and where evidence might come up, if you are on a scene that you think is being videotaped because there's surveillance cameras or because you're in a public place, just sort of registering that evidence exists. And so down the road, it might be really helpful to mention to your lawyer. And especially if there's a long delay between your arrest, wrong or otherwise, and the appointment of a lawyer, that gap in time can be really critical, especially if you really are trying to explain to somebody, I should not have been arrested. My parole should not have been revoked. My probation should not have been revoked. My bail shouldn't have been revoked because I was rendering aid. And you want to get that motion filed as soon as possible. You know, reaching out to whoever you can to start to collect that evidence, I think is going to be important in some cases. But that's like, ideally, we'd be able to sort of make notes to ourselves about the facts that we want to try to write down, you know, to follow up with.
Yeah, especially with sometimes it can be a couple months before you even get in for an arraignment.
Sure.
Yeah, and then months after that before you even actually get to your trial. So.
Right.
Awesome. So just being cognizant of the time, if you, unless, you know, either of you have anything to add, we can jump on to your slides that you have, Hillary.
Yeah, I might need you to help guide me. I have them here. I can see. Oh, ooh, wow. Magic. Okay, cool.
Yep. Yeah, I toggled them on and then I can switch.
Great. This is perfect.
Right.
I really seriously hope that you'll interrupt me with questions because I'm kind of a loosey-goosey presenter. And I think I've already covered some stuff. Like I've already mentioned a few things that are in here for sure. So we may jump around. And Megan, I'd love to hear your thoughts too. I have questions about the statute. So, just a quick, here are the things that I've made slides about at least. So I want to talk a little bit about background on the Fifth Amendment and our right against self-incrimination. I think just knowing the actual language and the rules free from context can sometimes just be helpful to have on board. And then applications, you know, how do we reduce harm in the interactions themselves on a practical everyday level? And if we have time, I would love to talk a little bit about court and working with a public defender, appointed counsel in Maine.
Sounds great.
I'm sorry, when I hit my next button, I get this chat. So I'm trying to get back into this thing. Just. Oh no. Oh. Okay, so I think the problem, is I had these coming in at different times, and the way that I've put it all in once, it's a little chaotic. That's okay. The only thing I really wanted to point out about this, so what's in this big block paragraph is the whole Fifth Amendment. It's all of it. But if you really cross out all of the yellow, so our first clause, which is the requirement that there's an indictment, the second clause, which is double jeopardy, also a really great movie, strike out the end. Fourth and fifth clauses, due process, everything's about due process. Just compensation, just like set that aside for a whole different class. The third clause is the right not to incriminate yourself, and that's really what we're talking about. So just to like put it all in context, we're talking about the federal U.S. Constitution that's separate from the Maine Constitution or any other state constitution. We are within the Fifth Amendment to the Constitution, and we are within the third clause. So really just like all the way from Google Earth down. And it comes from this really ancient principle that no man should be forced to accuse themselves. And it was written right in here and was interpreted by cases over, hundreds of years in the U.S. To ultimately become what we sort of, I think, all think of as the right to remain silent. So the person in this picture is Ernesto Miranda, who is the person involved in the case Miranda versus Arizona, which is where we get our Miranda warnings. I just like to always sort of put faces with cases. Miranda is actually a case about, I think, 6 different criminal trials that they combined. So the Supreme Court could talk about the right against self-incrimination, but it's a real person. It's a real individual whose rights were violated and who's had a criminal trial. And so I think it's helpful. And this language, if we really just sort of pull apart the case and read through what the justices were thinking about, I was looking at it again today and just realizing that it's ultimately a question about whether or not you're giving information over to law enforcement willingly, that you're consenting to that interaction, that you have waived your right to not say anything, and that you're sharing something willingly. And law enforcement can overcome your willingness to do that, right? By, in olden times, torturing you. And then over time, when courts and civil rights activists created protections against the third degree, ultimately we get to things like the Reid technique, where we know that some techniques can lead to false confessions. And so the whole point is that we want interactions with police officers, and particularly interrogations, to be voluntary. We want the evidence that's given to law enforcement to be credible. We don't want it to be something that's been dragged out of a 17-year-old that's on 2 hours of sleep. That's just not, good evidence, ultimately. So again, I think just like knowing it for yourself, going into any interaction is the best way to keep yourself safe. A bunch of this is straight from the Maine ACLU. Thank you, Megan. Know your rights for police encounters. I stole this line from somebody working on consent education, but I really think it applies here, and we should all just know this inside and out, that if you ask a police officer in any situation, am I free to leave? Anything but yes means no. So the answer is yes, you're free to leave, then GTFO. And if it's anything else, no, we could really use your, no, like that's a no, you're not free to leave. You can ask again, go. And I think practically speaking, it can be really tough just in any interaction with law enforcement to know whether or not you literally can remain silent. I've joked with friends all the time that I've been a public defender. I should know better than anyone these rights. And if I got pulled over, I would probably just immediately start like apologizing and just like pulling things out of my center console. Like, I'm so sorry, here's all my stuff. So realistically, it's really hard to remember these things, I think, in the moment. But one of the things that I think is like the hallmark of just stop and slow down is asking yourself whether you're trying to convince a police officer to do something or not do something. So if you find yourself trying to convince a law enforcement officer that this law protects you from arrest, then you've lost. You know, just at that point, you've got to sort of stop and hold on. The last thing I just sort of wanted to mention is that we're talking about criminal charges and whether or not you can be arrested, whether or not you can be prosecuted for something like possession of a controlled substance after having rendered aid. But those aren't the only risks that are involved with a police interaction. And I think it's important to recognize this is something that I think it's easy for a criminal defense lawyer to forget, but everyone's priorities are going to be different and everybody's needs are going to be different. But the war on drugs has long arms, and they go deep into things beyond the criminal justice system. They go into things like subsidized housing and federal student loans and children and family services. And so people who interact with law enforcement, particularly people who use drugs, know that the risks of eviction or loss of eligibility for benefits, all kinds of consequences can come aside from criminal cases. So that is not to say that this isn't an incredible piece of progress, but it's just also like we have a long way to go still, I think, in removing the effects of the war on drugs. And it's just helpful to sort of, I think, practice, you know, knowing what's important and what. And so this one more thing I wanted to just. So I mentioned the 911 calls thing earlier, but this is a slide just about emergencies in particular. And I think just sort of practicing, or at least talking about realistically, what are the kinds of things that you would say to a 911 dispatcher if you were on the scene of an overdose? What are the medical needs that you need to communicate? What's the purpose of that call? And I think trying not to speculate, right? If you don't actually know what someone's taken or why they're unconscious or why they're not breathing, I don't think it's helpful, or for you maybe to like speculate about that. But to communicate specifics like somebody is not responsive, somebody is struggling to breathe, you know, describing the location where you are, stuff that will help aid get there as soon as possible. And then once you are in a position where you feel like you're being asked questions and answering questions, it's just a matter of sort of assessing and slowing down, giving yourself enough time to sort of register. Am I answering the questions of an emergency medical technician or a police officer? And am I doing this willingly? Am I here because I'm afraid, or am I here because I want to be helpful and I don't feel nervous about what's going on? And I think that knowing, you know, do I feel like I'm under suspicion? If you do, know yourself, you know, go with your gut and ask if you're free to leave and start to move through the process of how am I going to move on, especially if medical services are there. This is something that I wanted to ask you, Megan, about the part of the statute with the protection, I think, lasts as long as the medical emergency and until police or EMS leave. I was curious if like police stick around after, say, somebody goes to the hospital. Do you know if the emergency, or is that a point at which you need to really find out, am I free to leave? Because, you know, the medical emergency is over. Police are still here. If you're in your own home or if you're at somebody else's home, I'm curious about when the protection might end, or if we have a clear sense of that.
Great question. Let me look it up really quickly just to make sure that I'm giving you like the precise language. I think it's until the police leave, but I'll just check that really quickly.
Yeah, that's definitely a really good question. I didn't even think of that.
And I'm just thinking about it because one of the realities that I feel like I absorbed over time was that, Megan said something earlier. I think about, I don't like to distinguish between violent and nonviolent. I similarly do not like to distinguish between perpetrators of crimes and victims of crimes, because I tend to think that people can be both. They can be both at different points in their life. All of our research shows that people who have been victims of crime or have perpetrated crimes have previously been victims. And so I just think those categories are useless. And I say that because it is true, I think, especially for folks who have been sort of sucked into the cycle of criminal justice, where probation or probation violation leads to incarceration, leads to, one thing after another, and it feels like this inescapable thing. It also creates these relationships that are so bizarre, right? Like, you might know a police officer really well, and it might be somebody that you joke around with a lot, or you see a CO, you've seen them once a month for the last year. Like, there's somebody that knows you, knows your parents, knows your kids, knows your family. Like, it's somebody that shows up to a call like this and says something to you that's really personal, that's like very intimate almost. It's like a relationship that goes back. And so when you're dealing with, that's nuanced, right? That's more complicated than communicating sort of cold, hard facts. And I think those interactions can be even more confusing and unsure about. It's understandable why you might be more unsure about what's going to be used against you later.
So many good points. So I wanted to tell you, so it says that the immunity it applies for the duration of the response to the medical emergency, and it ends when the medical professional or law enforcement officer leaves the location of the medical emergency. So okay. I think theoretically you should be fine, even if like the EMTs take someone off and the police are still there. Mm-hmm. But I think always it's such good advice to, like, when you start feeling like, wait a minute, it's been a while, or right. I'm like getting that sense that you're like, if the police are trying to engage you in conversation, and getting that sense to ask, am I free to leave?
Because one of the like bedrocks of our criminal procedure is that police have wide discretion to investigate. They have wide discretion to, based on if somebody appears suspicious, if they have a suspicion about the way that somebody's acting, or about they believe they have facts to believe that a crime is occurring. Our cases give police wide berth to investigate, to follow up, to sort of expand the scope of a search or an interrogation as they gather more information. And that's one of the reasons that I think it's easy to say I'm not incriminating myself because I didn't do anything wrong. And then down the road, you find out this thing that you said is being construed in a different way or being used against you. I think it's also true, right, that it can build up. That I think I've maybe gotten off track here a little bit, but I got distracted by the comment that came in.
Yep. Yeah, I was actually just
where I was going with that,
though. And read it out loud and see if either of you have an answer to this, because it was something I was wondering as well. Do individuals have any recourse when they've been involved in an overdose event and the next day their PO or whoever, they get a bail check or something, for a random urine after being informed, like by a police officer that you were there, like, if they got called back for a bail check or all of a sudden had a random probation check 2 days after the overdose happened and they know it's because, they're pretty
Mhm.
sure it's because of the cop, would they have any recourse?
Yeah, so the law says that it protects people whose identity was learned as a result of the response to an emergency. So so you should be able to file a motion saying, I was rendering aid and I was, and that's how they got that. Now, the hard thing about that is going to be proving it, like proving that the reason you got that bail check or the probation check is because of that identity. And I think that's where having an attorney is probably going to be helpful, because you're going to have to do that factual development. But there should be a way, like, you can file a motion and there are protections in the law, and it's supposed to be about, if your identity is learned because you were there, or if the grounds for your arrest were sort of determined at the scene, then you can file that motion. But yeah, you're probably going to need an attorney to help with the factual development.
Yeah.
And I think especially in the unofficial capacity, right? If one person sort of mentions to another, you might want to run a random screen on so-and-so. I saw them hanging out with so-and-so. The implication being, oh, pull them in for a screen this week. I mean, I think this is one good reason why conditions of release to remain drug-free are really problematic. Because if you're on a condition of release that says you must remain drug-free, that condition is true. That is a part of your requirements all the time. And so you're already on the, you have an uphill battle already. If you've got a positive screen, you're on conditions that said you had to remain drug-free. Now you're trying to say, well, they wouldn't have screened me if it weren't for the response I gave, right? I think that's going to be a tough argument. Even if we know that they only screened you because they heard from so-and-so that you were on the scene. So great thing to just sort of register, right? That I want to make sure so-and-so knows, my PO knows right away that I administered naloxone, or, I have folks that can vouch that I, was there rendering aid, because I think that's really helpful too, right? Being able to develop those facts, like you were saying, Megan, that kind of demonstrate, look, I was here on this night with these people. This is what I did to render aid. And this is, why I shouldn't. If the point of this is if we remind the courts, right, if our job as a lawyer, as a advocate, is to remind the court, look, this law exists to prevent people from hesitating to call. So let's remind everyone that, this person's going to think twice next time. Look at what we're doing.
There's also a law that we passed last year that says that probation officers are not supposed to reincarcerate someone who resumes use if your resumption of use is not a crime in and of itself. So if they find you in possession, that's a new crime, and so they probably would rearrest you. But if your screen pops, then theoretically they're not supposed to reincarcerate you. They're supposed to give you graduated sanctions. And so that's just another thing to know. Not only was I rendering aid and that's how you knew, but also the legislature has said we're trying not to send people back to prison for resumption of use. And so that's just another thing to know.
Yeah, and I just want to throw out a plug out there for the ACLU's Know Your Rights stuff. I'll actually be we'll be putting it up on our MAP Facebook. All the different Know Your Rights resources that I've been able to find online and in the state of Maine. And ACLU has ACLU of Maine and the National ACLU has a whole page that's full of different Know Your Rights guides. for different like situations. So I would definitely encourage anybody that's interested in, learning more about that to check out the website. And I'll see if I can find it and post it before the end of the live stream. But yeah, as far as like on that, so like it sounds like though, because the urine one, I could understand like technically, even if you were at the scene of the overdose and they call you in for a urine afterward, you technically still broke your probation or your bail or whatever because you were using. But I think it might be like where I think that might be able to be useful as far as Chastity's question is like if the police were to like if they were try to revoke your bail because you were around somebody with drugs because you were at the scene of an overdose, then you'd have like the type of defense of they learned my identity through that and are trying to charge me just based off that. But another good point on why it is a good idea to always consult with a lawyer if you're able to. And Hillary, thank you, Megan, for sending those. And Hillary, the one that's doing tech for us, she shared the sites for the ACLU Know Your Rights guides. If anybody wants to check those out. And if anybody else has any more questions, feel free to post them in the chat. And I know, Hillary, you did also, if we had time, want to talk about a little bit about the courts and criminal cases.
Sure. I mean, I'm happy to also just talk about, I mean, I don't have a lot more to say. Well, I always have plenty more to say. We could talk for hours, but especially about public defenders and why I love public defenders. I'll leave it up to you. Do you have any other topics, like any other stuff about Good Samaritan that you want to get into? I feel like I don't want to use up our valuable time with Megan to hear about the statute itself. I think it's worth looking at it and knowing it really well. And I think it is a good segue though about working with your lawyer and how to get a lawyer. One of the rules that they'll read to you in your Miranda warnings is that you have the right to have an attorney present for any questioning. And if you can't afford a lawyer, one will be appointed for you. In reality, though, if you're being questioned right now and you say, I want a lawyer will not pop up out of the blue. That is just not how that happens. Even if your lawyer is in the station, like banging on the door, they might say, you have to go to court. You've got to wait until we get to the courthouse for arraignment. I think it's just like being prepared because on TV, lawyers show up to interrogation rooms all the time. It's like very rare. And it's often when the police are investigating an ongoing case, right? An ongoing crime. We're not talking about big investigations here. We're talking about sort of these one-on-one interactions or this sort of like discrete period of time. So practically speaking, if you're saying I want a lawyer present, if you know a lawyer, a criminal lawyer, and you have their number and you can contact them, great. But remember that your calls still may be recorded if you're in custody, that anything that you say while in custody, unless you are speaking privately in person in a room with just a lawyer, you should not assume that anything you're saying is confidential. Once you get to court, during your arraignment, that's when the right to counsel is sort of dealt with, right? And in Maine, I don't practice criminal defense. I want to be really clear about that. I am not a public defender in Maine. So this is not legal advice about criminal cases in Maine, but I believe what happens often is you see a lawyer of the day for a bail hearing at your arraignment. And that person may not actually end up taking your whole criminal case. They will just be there for that day, deal with your bail hearing, and then your case then is assigned to a lawyer on the list, and you might see them if you're still in custody, they'll come visit you at some point. If they're not, you'll try to set up a time to talk with them about your case. I know that process is, there's some real gaps in time there that can create some real problems for folks. And it's those gaps in time I think are also super relevant to whether or not any information you're sharing is voluntary, right? As more time goes by while you're in custody, the more tempting it gets to try to explain why you need to get released. And I think the longer you go without a lawyer, if you say, I want a lawyer, but 4 hours later you're saying, I think I would be happy to talk with you, even if a lawyer's not available. That is a real thing that could happen, right? I mean, that's just knowing that we can wear down, that we can get tired, that we can get frustrated, and that we can sort of lose the ability to assert those rights. The best thing that we can do is just sort of know ahead of time and be prepared. And I also think the ACLU and the National Lawyers Guild, I really love the National Lawyers Guild Know Your Rights content. They have some great pamphlets that are pocket-sized for protests specifically, and then other police encounters. But they also have a service where you can contact lawyers, particularly if you're involved in demonstrations or protests. NLG will often have legal observers there or attorneys ready for arrests on like a larger scale. That's one organization that may be able to provide legal services while, awaiting arraignment, but that seems unlikely in a lot of cases. And so I think especially if you can't afford a lawyer, if you don't know somebody on your own who would be able to represent you right away, it's a waiting period. And that's just like one of those true inequalities in the system. One of the many, many ways in which it's two different systems for people with money and people without.
No, that's definitely helpful. So, Megan, I do see that it's 7:29, but I wanted to give Megan a quick chance to add in if you have anything to add.
I think the thing that I keep thinking about after we're talking tonight is like making a plan ahead of time and sort of practicing it a little bit before you get into these situations. So knowing that if you are in public housing, if you have a voucher, if you're in public housing, that like you could be in danger even if you're not arrested, knowing Child Protective could be called. Like, I'm not trying to scare people, but just like thinking through your risk factors and making a plan to the extent you can, and even practicing with someone a little bit beforehand. It feels cheesy, but in law school, that was the best way to practice, was like put someone in a situation and have someone play tough person, and like, how do you respond to that, so that you have some muscle memory when you're actually in that situation and the cop is trying to either be your friend and get information out of you or not be your friend. Just like making sure you have a plan and you know what your risk points are, and like thinking that through now as opposed to in the moment will be really helpful.
And especially like, well, maybe not especially, but I know that I react in times of stress, really high stress. My body just responds differently. My thoughts start racing. I start talking really quickly. And all of those things are exactly the opposite of what I would want to do in a police encounter. I don't want to talk. I don't want to talk fast. I don't want to say as much as possible. I want to slow down and try to, listen more than, like, if I don't know whether or not I'm free to leave, I shouldn't be expressing any information, period. For me, I'd have to really practice just like taking a breath, trying to be calm, trying to center myself so that I can just understand what's being asked of me, what I'm being told, how I'm being directed. I couldn't agree more that practicing and just knowing your strengths and weaknesses and your priorities, and if it's, especially with kids in housing, I always tell folks, like, what could be more personal, right, than your family, your housing, and a loved one being in medical crisis or incarcerated. I mean, those are, I can't think of anything more personal or more emotional. So talking about it so that we're comfortable talking about it, especially with peers, is great. And, you know, when you're watching movies and TV and you see police interactions, talking about like, I don't think they, you know, I think they violated that rule. I think that this would have been how I'd handle it. I'm insufferable, but I say do it, and it's helpful.
Yeah, no, I definitely agree. Like in our overdose education, in our overdose education and naloxone distribution classes, we focus pretty heavily on doing like safety planning. But I think that's a really good point of, working what might happen if the police do show up into that safety planning, because I mean, like you said, you have that muscle memory, and it's a lot easier to go through something if you've had the practice beforehand, then especially when stress and everything's just going so fast. Definitely a good idea to safety plan. Awesome. So, and definitely like what was put in the chat, if anybody wants any help with safety planning, wants any support around overdose education, support on, with after the fact of responding to an overdose, definitely reach out to Main Access Point. We'll be more than happy to help you. Awesome. And I thank you both for coming to the live stream. I think this was a very informative night, and I'm super happy that you both joined for the live stream.
Thanks you
for
so
having
much,
me.
Mickey. And thanks for the folks who popped their heads in the chat too.
Yes, definitely. And thank you to all of our participants and everybody around the state who is constantly, who is working within their community to save lives.
And thank you for all your work and your service.
Yeah,
I mean,
seriously.
With regard to what Hillary said in her testimony, I mean, I think you're heroes.
For real.
Thank you.
It's true.
Well, have a good night, everyone.